Cpc and Limitation Act. Object of limitation. The law relating to limitation is incorporated in the Limitation Act of 1963. Which prescribes different periods of time taken for suits, petitions and applications. The Act applies to all civil proceedings which can be taken in a court of law unless its application is excluded by any enactment. The Act applies to all civil proceedings and some special criminal proceedings which can be taken in a court of law. The law of limitation bars the remedy in a court of law only when the period of limitation has expired, but it does not extinguish the right that it can't be enforced by judicial process. Case Bombay Dyeing and Manufacturing vs. State of Bombay, AR 1958. This is a claim satisfied outside the court of law after the expiry of period of limitation that is not illegal. Legal disability. Persons under legal disability. Section 678 of the Limitation Act 1963. Section 6 is enabling section to enable persons under legally induced disability to exercise their legal rights within a certain time. Section 7 supplements Section 6 and Section 8 controls these sections and serves as an exception to Section 6 and 7. 6 and 8 together say that where the prescribed period of limitation expires before the cessation of disability of instance before attaining a majority, the minor will no doubt be entitled to a fresh period of limitation from the attainment of his majority subject to conditions. 6, 7, 8 must be read together. Section 8 limits the concession to a maximum of 3 years after cessation of disability. The 3 years should be counted from the date of cessation of minority or disability. Computation of limitation and appeal. Period in days under Limitation Act for appeals against the sentence of death passed by a court of session or a high court in exercise of its original jurisdiction. The limitation period is 30 days for an appeal against any sentence other than a sentence of death or any other not being an order of acquittal. The period of 60 days from the appeal to high court and 30 days for an appeal to any other court in prescribed period of leave to appeal as a pauper from the date of decree is 60 days when the application for leave is to appeal to be made to HC and 30 days to any other court. The state can't place any hindrance by presenting a period of limitation in the way of an aggrieved person seeking to approach the Supreme Court of India under Section 32 of Constitution of India. It is against the state action that fundamental rights are claimed. Trilok Chandi versus H.P. Munshi. The Limitation Act does not apply to proceeding under Article 32 or Article 226 of Constitution of India, but where the remedy is a writ petition corresponds to a remedy in an ordinary suit and the latter remedy is subject to bar of limitation. The High Court, Supreme Court in writ jurisdiction adopts its own rule of procedure and in the absence of special circumstances imposes the same limitation in writ jurisdiction also. Condonation of delay. Section 5 of the Limitation Act deals with the condonation of delay. COD is a remedy provided to a party if they fail to approach the court during the limitation the law has provided to them. It is a remedy where a meritorious case has been heard after providing a sufficient cause to the court. When the prescribed period is ended, it is a matter of discretion of the court. An order condemning the delay without assigning the reason and without recording sufficient cause is not in accordance with law. Interpleader suit. Interpleader suit in CPC is defined in Section 88, read with Order 35. An interpleader suit means any person claims any property of the husband or her parents, and in case the owner of the property is dead without transferring the property, then the second owner has to claim the property from bank or authority. After claiming for such property, the bank has to file an interpleader suit in court. The court will then decide the ownership if many claimants are there. Then he gets the monetary value. Conditions for interpleader suit. One case relating to debt, money or property. Minimum 2 defendants. Both defendants can claim each other for the property. Person who has to pay the debt to the defendant is not valued for interest. The claimant is willing to pay the debt, money or property to the defendant. No suit is pending in this regard. The suit can't be filed twice if the judgment is given in res judicata. Affidavits. Section 139 and Order 19 of CPC, read with Order 11 of SC rules, deal with the affidavit. The affidavit is a type of verified statement that contains a verification. It is given under oath or penalty for perjury, and this serves as evidence for its veracity and is required for court proceedings. It is thus a sworn statement of facts given by a person who is privy to the facts and circumstances relating to the same. The person who makes it signs it and is known as a deponent. It states in the knowledge of the person who has signed it and has nothing concealed material therefrom. It is duly attested by a notary or oath commissioner appointed by a court of law. His duty is to ensure that the signature of the deponent is not forged. The affidavit must be paragraphed and numbered. Essentials. A declaration made by a person relates to facts and not inferences. Written in first person, a sworn statement affirmed before a notary or a magistrate. Stay. Stay order refers to stoppage, arrest or suspension of judicial proceedings. It is passed against the execution of a decree to allow judgment debtor to appeal against the decree, or it is alternate in some cases, and judicial dissension in another. Stay order is under Order 39 and Rule 12 of CPC. CPC to section deals with stay. No court will proceed with trial of any suit in which there's an issue is also directly and substantially in issue is a previously initialed suit between the same parties or between parties under when they or any of them claim the litigation under the same title when the same such suit is pending in the same or any other court in India having jurisdiction to grant the relief claimed in any court beyond the limits of India. Pending of a suit in a foreign court does not stay the proceedings in India founded on the same cause of action. Injunction kinds. Order 39. Injunction are under Order 39 Rule 1. There are several types of temporary injunction, permanent injunction, preventive injunction, prohibitory injunction, restrictive injunction. Temporary injunctions are under Order 39 Rule 1 to 5 of the CPC and Section 37 of the Specific Relief Act 1963. Permanent injunction are under Section 38 to 42 of Specific Relief Act 1963. Ex parte injunction is under Order 39 Rule 3 of CPC. Injunction is a disciplinary relief. Discretionary relief. Injunction should be granted A. to maintain status quo for disposal of the goods, for construction of effecting recovery of dues, for attachment of property, for appointment of receiver, against transfer of property, against prosecution. Injunction which can't be or may not be granted against recovery of tax or octroi, for enforcement of contractual rights and liabilities, for transfer or suspension of the employee, to delay election process, to interfere with inquiry or investigation, attachment and sale. Section 60, 61, 63, 64, Order 21, Rules 41 to 57 deal with attachment of property of judgment debtor, property liable for attachment and sale. In execution of a decree, the aim of attachment is to prevent alienation of judgment debtor, notice to general public not to purchase deal with property so attached. Section 60, Clause 1 lists out properties that are liable for attachment and sale. Section 60, 61 lists out properties which are not liable to such attachment or sale. Section 61 gives partial exemption for agricultural produce that is necessary for the purpose of providing for the family until the next harvest. Order 21, Rule 43 deals with attachment of movable property other than agricultural produce shall be made by actual seizure. Section 64 says private alienation of property after attachment is void. Effect of attachment comes to an end only when the decree is fully satisfied. It prevents and avoids private alienation, but does not invalidate an alienation by operation of law. Example, vesting order under Act of 1848 and an order on sale, it binds the parties but does not confer any title. Costs. Section 35 CPC deals with costs. The cost of an incident to all suits shall be in discretion of the court. The court has discretion to determine whether the costs are payable. Quantum and the timing. Costs include witness expenses, fees, legal expenses and fees, miscellaneous expenses. General rule is unsuccessful party shall be ordered to pay the cost of successful party. If the court deviates, it should give reasons in writing. Court should look into the circumstances as below: conduct of the parties, whether successful in case, whether frivolous claim, counterclaim is made, whether unreasonably refused by the other party, whether party has made frivolous claim and instituted vexatious proceedings. Execution. Section 82 deals with the execution of decree or an order, the last stage of litigation, that is implementation of the court order, funding of judgment or decree, is known as execution. It is the obligation of the person judgment debtor to give effect to the decree. To enable the decree holder to enjoy the benefit of judgment, it is compulsory. Execution means enforcing or giving effect to court judgment by compelling a judgment debtor to carry out the mandate of court and enable decree holder to recover the thing granted to him. In Section 39, CPC says that a decree can be executed by either the court on the first interface or instance or by a court to which it is sent for execution. Section 37. Further details, courts which passed a decree. Section 39 provides that when a decree holder makes an application to the court of the first instance to send the decree for execution to another court, it may do so the same subject, conditions and grounds listed. Section 39, Clause 2 deals with the suo motu sending order of execution to a subordinate court. Mahadev Prasad Singh versus Ramlochan held that Section 39 is subject to discretion of the court. Suits by indigent persons. Order 33 deals with CPC deals with suits filed by indigent persons. They can constitute and prosecute suits without payment of any court fee. A person is an indigent person if he has not possessed of sufficient means to enable him to pay the fees prescribed by law for plaint in such a suit, or if he is not entitled to property worth of 1000 rupees. Order 44 of CPC provides for institution of an appeal as an indigent person. Object of the Order 3344 is to enable a person who is ridden by poverty to seek or appeal for justice. E.A. Hassa Moinuddin versus Union Railways, Union Bank of India versus Khada. Suits by against government. Section 79 to 82, Order 27, 27A. Suits can be filed by or against the government or public servants, by citizens and vice versa. In case of central government, it should be filed in the name of Government of India, Union of India, represented by Secretary to Government. Article 300, Constitution of India. Government of India may sue or be sued in the name of Union of India, and the state in the name of the state government. Section 79 specifies the authorities to be named in the court hierarchy. Section 80 bars instituting a suit for work done in official capacity until expiration of 2 months after the notice. Kansham Das versus Union of India. Section 81 for an act in official capacity against a public officer not liable to arrest, no attachment of his property, seek exemption from appearing in person. Section 82, a decree shall not be executed except as per 82.2, Order 27, Rule 1, who shall sign on behalf of the government. Order 27, Rule 2, indicate who is recognized as agent and appear on behalf of government. Order 27, Rule 3, gives the name and description and place to be followed as per Section 27. Order 27, Rule 4, indicate who will service process issued by the court. Bar of suit. Next heading, bar of suit. Section 9 of CPC declares the court shall have jurisdiction to try all civil suits except suits of which their cognizance is either expressly or impliedly barred. The jurisdiction of the court is decided by the legislature. Parties cannot interfere. SURFACE Act 2002 bars civil suits jurisdiction, civil court jurisdiction. So, suits related to right to privacy, suits related to caste, suits related to establishing dignity, suits for special tribunal are expressly barred by legislation, suits related to religious rights and matters pertaining to that which is discharged then in due course of law. Suits impliedly barred are based on general principles of law or based on public policy. Section 11 deals with double suits. Hriday versus Ramchandra, Dulave versus Province of MP, State of AP versus Lakshmi Kantrao. Next, receiver. Under order, CPC receiver is an independent and impartial person who is appointed by the court to administer or manage, protect or preserve a disputed property involved in a suit. It is form of interim protection. Receiver is an officer of court. He is empowered to deal with the property and manage it in decrees passed. It is custodia legis principles. T. Krishna Swami Chetty versus Tangavelu Chetty. A, discretionary power of the court. B, protective relief to the plaintiff. C, plaintiff should have a strong case. D, it deprives the defendant of the possession, hence hard remedy. E, resort to only if it will do no harm. F, only when this is a possibility of wrong or injury. G, look at the conduct of the parties. That is, the party should come to court with clean hands as it is equitable relief. Reference. It means sending any matter for opinion. Example, Union of India to Supreme Court. It is dealt with on Section 113 CPC. A subordinate court can refer a matter to High Court on a question of law when there may be an application or suo motu. The object of the reference is to get a higher court's opinion to avoid commission of errors. Conditions for reference. A, pending suit. 2, during the course of suit. C, reasonable doubt on question of law. Normally, proceedings are stayed till higher courts give their opinion. Dismiss for default. Order 9, Rule 9 CPC deals with the dismissal of suit for default. According to the Order 9, Rule 5.1, where after a summons had been issued to the defendant and returned unserved, the plaintiff fails to for 7 days to apply for issue for fresh summons, the court shall order suit be dismissed unless the plaintiff satisfies the court that who files to discover defendant's residence, defendant is avoiding the service of process, any other sufficient cause for extending time. In camera proceedings, Section 153B, place of trial to be deemed to be open court proviso. The presiding judge may, if he thinks fit, order at any stage of inquiry or trial that the public generally or any other particular person shall not have access to or be or remain in the room or a building used by the court. In camera proceedings are held before a judge in private, in court, on his chamber, and press and unconnected public from the hearing press and the media are not allowed to public in camera proceedings. Section 22, Hindu Marriage Act specifies proceedings to be in camera. Section 11, Family Courts Act specifies proceedings to be in camera. Instances of obscenity and exam and cross-exam in case of sexual assault, rape and cruelty are held in camera. Marking documents. Marking documents as an exhibit by assigning alphabetical or numeral or combination, usually for the purpose of identification. Order 7 CPC creates the production of documents by plaintiff. Order 8 CPC relates to production of documents by defendant. Order 18 Rule 4 CPC examines in chief shall be filed in the form of an affidavit with a copy to the opposite party. Order 13 CPC Rule 6 to 11 deal with the production, impounding and return of documents. Mere marking of an exhibit via document does not amount to final proof thereof. Next, review. Review means to reconsider, to work again as to re-examine. Review is dealt with under section 114 of CPC. It is done by the same court and the same judge. Article 20, Rule 3 makes the judgment duly signed and pronounced as trial, but section 114 provides for an exception to the rule. The section does not provide for any limitation and conditions for review. Section Supreme Court, High Court have the review jurisdiction. Conditions for applicability and application for review may be filed by any person if he is aggrieved by any civil court decree. Once review is filed, there is no legal bar in filing an appeal. Discovery and inspection of evidence, apparent mistake or error. Union of India versus Naresh Kumar, Bhadri Kumar Jugat. When SC held, even a third party, if he is aggrieved, can avail of a review or remedy.